Well, welcome to this afternoon's session of the Kansas Court of Appeals. We appreciate counsel's willingness to meet with us remotely today by Zoom. This case is set for 15 minutes. It is the State of Kansas, ex-rel State Board of Healing Arts versus Shawn Parcells. And may I have your appearances, please? Oh, I'm sorry. Let me say first, do my own appearances. My name is Catherine Gardner. I'll serve as the presiding judge. And so essentially I'll be keeping time today for 15 minutes. And I'm happy to sit today on our panel with Judge Stephen Hill, one of our longest serving judges, not the longest, and Judge Leslie Isherwood as well. So counsel, your appearances, please.
May it please this honorable appellate court, the appellant appears by and through his counsel, Eric Jorley, and for the corporations.
Thank you.
May it please the court, Courtney Sisman, General Counsel, appears on behalf of the appellee, Kansas State Board of Healing Arts.
Very good. Mr. Jorley, would you like any rebuttal time today?
Your Honor, I would like to have to reserve 2 minutes only. I don't expect to use it, but I would like to do that.
You may do that, and you may begin.
Thank you, Your Honors. May I first advise the court, I appreciate the opportunity to talk to the Honorable Court of Appeals on this case. I am currently in Charleston, South Carolina, where there are more lawyer commercials than car commercials. And there may be a jet that'll go over that may interfere a little bit, but we're in the flight zone and we're down in the French Quarter. At any rate, Charlestown, Blackstone, English common law probably began in our country where I am at the moment. Judges, I have 2 points on appeal. The first is that the Honorable District Court should not have granted a motion for summary judgment based on the fact that the current record on appeal does not comply with 2020 PR 58, which is a notice that must be given before a summary disposition is permitted because of the COVID rules of the Kansas Supreme Court, the appellate court. The second is that under the summary judgment rules, there has been on this record on appeal, Mr. Parcells and his companies have provided substantial evidence that they controvert that the State Board of Healing Arts right to say that he could not use the PA designation. And importantly, this kind of dovetails into the federal case. There are 3 cases that the Attorney General brought. This is the trifecta, but there's an elephant in the room, and that is the federal criminal case, the wire fraud case. And in that, Mr. Parcells probably, as I understand it, will enter a plea. And I'm not sure what the grounds would be, but it could be based upon false representation of a location of a business. And it does not intertwine or somehow conflict with this litigation. In 2013, the appellant and a Dr. David Burrell came under the scrutiny of the State Board of Healing Arts, and my client was privileged to be represented by now Shawnee County District Judge Lori Doherty Bichelle. And in that particular matter, it was clear that there was no problem with the State Board of Healing Arts concerning the relationship of Mr. Parcells and Dr. Burrell, who is a board certified pathologist. That they performed their work under the provisions of the State Board of Healing Arts. In other words, Dr. Burrell requested Mr. Parcells to provide certain services, which included a pathology assistant work. And our arguments we would like to present to the district court are that he is practically trained to provide pathology assistant work for pathologists, and academically, he has certain credentials that are important.
Mr. Jorley, may I
yes.
ask you a question? When you say you would like to put that evidence in front of the district court, didn't you have the option to give that to the court already in terms of a statement of an uncontroverted fact?
We did not. We did not reply to their motion for summary judgment due to the fact that COVID was going on and we had 3 cases. The first case was 2019 CR 17, a Wabunsee County case, and that's a criminal matter that we were involved in. Mr. Parcells Mr. Parcells is now subject to a federal criminal case, and we had also a consumer protection case. And that case, unfortunately, is set for trial this fall for a 1-month trial. And I say unfortunately because all of the work I've been provided my clients in this matter, I've done this pro bono. The State Board of Healing Arts, nor the Attorney General on these other companion cases has ever attacked the validity of the reports, only the credentials of my client. And we would like to be able to present that, although we have made a good faith offer of judgment, and we have done this from the beginning of this litigation in this particular case, which is the 2019 CB 266, the State Board of Healing Arts case. And the offer of judgment does about everything except give them a admission that my client could not use the PA, and that is something that we believe is hotly contested. We answered a 256 count petition in the consumer protection case, and I'm not sure how many requests for admissions in the instant matter in the State Board of Healing Arts, but we've always denied that, and we wanted to make sure that we hopefully would have the court look at the fact that we have COVID, and secondly, the recent case of the Harrington versus City of Wichita, where the principles behind the rulings are the important issues. There's no element of surprise. We, in terms of Rule 141, which I believe is the basis, one of the basis for establishing Rule 141. So we're saying that the importance of the ruling is important on appeal, and it should be more important than expediency.
Mr. Jorley, let me ask you about those admissions in the consumer protection case. It seems like our statutes speak pretty clearly to that, and saying in 6236 that a request for admissions and a response is for the purpose of the pending action only. What's the district court to do with that?
Well, the judge needed to, if it was going to rule, because we did have some other interim rulings, the court did grant some extensions based on the fact that Parcells was involved in the Wabunsee County criminal case, and there might have been some problems in terms of requests. That's one issue. The other is that the court never did comply with the Supreme Court rule that was required for notice in 2020 PR 58. I did not make that a part of the brief, but I became acutely aware of that when I was involved in another matter, and that I think was explained in the motion I filed for extension. The Honorable David Bruns provided an order requiring that paragraph 4 should be important. And I would just advise the court in argument only that when the decision was made, on appeal, which was timely, we appealed the order of October 9, 2020, and on November 3rd, and remind the court, this is all pre-vaccination, but no pre-vaccination, there was no vaccination protection that was provided to litigants, and we would like the court to at least indicate that on the issue of PA under Rule 141, that there's sufficient, that they had knowledge of the fact that we definitely controverted that. And secondly, that under COVID, the court could not rule without complying with the Supreme Court. I think that's the gist.
We're getting a little feedback there from somewhere. I don't know what that is, but Mr. Dorley, can you hear us?
I can. I can also see the transcript. Can you hear me?
Yes, we're good.
Okay.
You have about 3 minutes left before your rebuttal time.
Your Honor, the element of surprise under Rule 141 in terms of admitting the fact that there's an elephant in the room that should be taken into account when applying the law in this matter. And again, the fact is that Mr. Parcells has never been accused of not applying appropriate science to any of his dealings under the supervision of a pathologist, and only trained as a pathologist assistant by virtue of his training and not by a credential or degree, which is not required in Kansas. In most states, it's not required. Thank you.
Okay. Any questions from the panel? Okay. Ms. Seisman, please go ahead.
May it please the court. The Kansas State Board of Healing Arts is a state agency that is tasked with the authority to license, regulate, and discipline practitioners of the healing arts in Kansas. The purpose of the board, as set out by Kansas legislature, is to protect Kansas patients from the unprofessional, improper, unauthorized, and unqualified practice of the healing arts. In Kansas, it is unlawful for any person who does not have a license to engage in the practice of the profession regulated by the board. Appellant has practiced the unlicensed practice of medicine in Kansas. He has misled the public in his credentialing and has performed autopsies on Kansans despite not being licensed to practice any profession regulated out by the board and without proper supervision, to the detriment of Kansas families. To protect the public, the board sought injunctive relief in April of 2019 against the appellate in district court. In this case, the district court was correct in granting the board's motion for summary judgment and granting injunctive relief authorized under law, as there really is no genuine issue to any material fact, and the board was entitled to judgment as a matter of law. It's important to note at the outset of this case that this is not a companion case with any of the attorney general cases or the federal case mentioned. The board's case is separate and distinct in fact, law, and jurisdiction. We were requesting injunctive relief under the Healing Arts Act, which is within our jurisdiction. I want to first address appellant's argument that the district court incorrectly granted summary judgment for failing to consider disputed facts in the attorney general's case. That argument lacks any sort of legal basis, and opposing counsel has failed to cite any legal authority for that because it is none. And it does run completely contrary to the rules of civil procedure. If we were to accept that argument, then what meaning would they have? I also want to briefly run through a timeline of this case as it relates specifically to COVID-19, because I think it is important and critical. So the board filed the petition in April of 2019. We served our first set of interrogatories, requests for admission and requests for production in June of 2019. We had a deadline to respond in July 2019. We sent a golden rule letter in July of 2019. And then we filed a motion to compel in September of 2019. The district court ordered that the defendant to respond to the discovery by October 25th, 2019. He did not. And then we again moved for it, and he then had to respond by January 31st, 2020. It is not until March 12th, 2020 that the pandemic came about. So this was pretty much nearly a year in which he could have responded to it. So that's important as it relates to this case.
Could you, I presume your summary judgment was at several months after that. Do you have a date handy for that?
So we filed our motion for summary judgment relatively early on in this case, November 2019. November 27th, 2019.
Thank you.
So, okay, so turning to summary judgment. So obviously the board did move for summary judgment in this case. And when opposing a motion for summary judgment, the opposing party cannot merely rely on these blanket allegations or denials. They have to submit affidavits or set out specific facts showing a genuine issue for trial. More specifically, they have to come forward with evidence to establish that a dispute actually exists as to a material fact that is also conclusive to an issue on the case. Here, the district court was absolutely correct in granting such summary judgment on count one, as the evidence in the record demonstrated that he had unlawfully practiced medicine in Kansas without a license. Appellant has never really disputed the fact that he has never held a license to practice any profession regulated by the board, including a license to practice medicine and surgery. Now, Kansas law does require autopsies to be performed by physicians, but this record is undisputed in the fact that he has performed an autopsy on a patient in Kansas and without the proper supervision of a physician, and that he also wrote autopsy reports. And this is a part of our request for admissions. On volume 1, page 77 of the record of appeal, we specifically asked him, do you admit that you have performed an autopsy without the presence of a pathologist licensed to practice medicine and surgery in Kansas? That has been deemed admitted. All of the requests for admissions have been deemed admitted. Do you admit that you have written an autopsy report for an autopsy performed in Kansas? That also has been deemed admitted. And do you admit that you performed an autopsy on Kansas patient 1? That is deemed admitted. He has also attached words to his name indicating that he is a physician or engaged in the treatment of diagnosis of ailments or diseases. A prime example of this is during our hearing, our Zoom hearing during COVID at the district court for the motion on summary judgment and or default judgment. And during the hearing, appellant joined with the login name Doc Parcells. All we have in this case in the record in terms of dispute is blanket assertions from the appellant. That is insufficient under Kansas law. He has had ample opportunity to come forward with evidence to dispute it. You know, he's also argued that he was under the proper supervision of a physician consistent with Kansas law, but he hasn't come forward with any affidavits from those physicians. There's no evidence showing that defense. The legal standard is not just to take the appellant or the opposing party of a motion for summary judgment at their word. You have to come forward and show something. And the district court was correct in saying there is nothing controverting any material fact in this case. So here we are nearly.
Could you answer for me what happened after you filed the motion? Did they respond with a a response to the motion for summary judgment, or what did they do instead?
So they did not, after we filed our motion for summary judgment, they filed a motion to stay the discovery. We ended up amending the consent order. And then he eventually did respond to the motion for summary judgment on January 31st, 2020. But there was no response to discovery, which the district court had requested and was contingent on that extension. So that his response to our motion for summary judgment was also prior to COVID. So the district court was also correct in determining that on count 4 that the appellant violated Kansas law KSA 6528A06 because he had used the abbreviation PA after his name. That indicates to the public that he is a licensed physician assistant. That statute specifically states that no person shall use any title, abbreviation, letters, figures, sign, card, or device to indicate that they're a person licensed as a physician assistant. The acronym PA is the abbreviation for licensed physician assistants, and that's undisputed. That appellant has used it after his name. It's actually replete throughout the record, instances of him using PA after his name. But the significance of this is clear when you consider it from a patient perspective. It is completely reasonable for a member of the public to believe PA indicates licensure as a physician assistant when you're thinking about it in the context of what he was doing, offering services that are reserved for physicians or under the supervision of a physician. Here, appellant has blanketly argued without presenting any evidence that PA was properly used, indicating he was a pathologist assistant. But that argument is absolutely without any evidence in the record. There is no evidence he has attended an accredited pathology assistant program. There's no evidence in the record he was trained by a physician to be a pathology assistant, only his work. There is no evidence that he has taken the pathology assistant certification examination, and he is not a member of the American Association of Pathologist Assistants. So the record just truly does not support this claim. He has had time to bring forward this evidence, but he hasn't. So because he failed to produce any evidence to support his claim, the district court was correct in finding that as a matter of law, he had violated KSA 6528A06 by using the designation PA after his name and properly granting injunctive relief to the board. On the other points, so the district court also properly granted summary judgment on count 2, as it's undisputed that he violated KSA 652867 by maintaining an office for the practice of the healing arts and held out to Kansas his intention to do so without having a license. Appellant, so we've already established that appellant has never really disputed he lacks any license. Nevertheless, he has maintained general corporations where he unlawfully practiced the practice of healing arts by performing autopsies while operating Parcells Forensic Pathology Group, National Autopsy Services, Kansas Regional Forensic Services, Kansas Forensic Experts, Kansas Forensics, Parcells and Company, and National Autopsy and Tissue Recovery Services. And it's really clear from these names alone that he has repeatedly held himself out to the public as having the skill or authority to practice the healing arts. Those reasonably indicate that that company can perform autopsies, tissue collection services, but he has completely failed to dispute it. We have no discovery responses from him, no evidence, nothing. And somewhat in conjunction with count 2, the district court also properly granted summary judgment on count 3, in that he engaged in the unlawful, unlicensed corporate practice of medicine by maintaining those general corporations and having unlicensed directors or shareholders, here himself. In Early Detection Center v. Wilson, the Kansas Supreme Court has held that general corporations who have unlicensed directors or shareholders are not authorized to practice the healing arts. It is through these general corporations, as we previously mentioned, that he engaged in the corporate practice of medicine by performing the autopsies without a license. And he has completely failed to adequately dispute the facts. So in conclusion, the board respectfully requests that this court affirm the district court's ruling in its entirety, granting the board summary judgment and all the injunctive relief requested, because there really is no genuine issue to any material fact, and the board is entitled to judgment as a matter of law.
Thank you, counsel. Mr. Jorley, you have 2 minutes.
Thank you, Your Honors. The public has been protected by a restraining order that was issued out in the consumer protection case. Mr. Parcells nor his companies can do any tissue recovery or work with pathologists to perform autopsy services. Now, again, I think our authority was the Osterhaus v. Toth case, 291 Kansas 759, 2011, that summary judgment may be appropriate if the pleadings, depositions, answers to interrogatories show there's no genuine issue of material fact. I think there is a genuine issue of material fact when the State Board of Healing Arts on September 16 of 2013 issued out an opinion indicating that Mr. Parcells' work with a Kansas pathologist, Dr. Burrell, was appropriate, and that and at that time the board took no action other than to ensure that in this case, there was a Kansas pathologist. Where we got into some difficulty, we were using pathologists that weren't Kansas doctors, fairly highly trained pathologists. Dr. Hua, H-U-A, who is very similar in work to Michael Baden, B-A-D-E-N, who did the work along with Mr. Parcells' efforts as a tissue recovery specialist in the Michael Brown case, the St. Louis case, the 2014 case. The elephant in the room again is that there is a federal case. There is continuing, and actually the Kansas case is not fully gone through the stages, although we were convicted. But there is a sentencing that will occur in that matter. But again, the wire fraud issues are still apparent, and we believe that the court was in error granting summary judgment. And also, the court was in error on the record to indicate that there was no genuine issue of material fact in the land of COVID, which we believe that the Supreme Court rule should be enforced, and that the public is protected by our good faith offer of judgment that basically provides exactly what the State Board of Healing Arts wants to do, and we stand by that defendant's good faith offer of judgment, which was Appellant's Appendix B to the brief. Thank you.
Thank you to both counsel. Any questions by the panel?
No.
We will then take the argument in the case under